Welcome, welcome, welcome once again. In the name of Allah, the Beneficent, the Merciful, I bear witness that there is no God but Allah, and I bear witness that Muhammad is his messenger. Yes, we are finally back once again with another video, hoping that it will be educational and informational to you, and that it will be of benefit to you as well. This video is called Preventing Public Corruption or the Appearance Thereof. Let us begin. In the case of Hills versus Bridgeview Little League Association, it was said to establish a cause of action for negligence, the plaintiff must establish the existence of a duty owed by the defendant to the plaintiff, a breach of that duty, and an injury to plaintiff proximately caused by the breach. To recover damages based on negligence, the plaintiff must allege and prove that the defendant owed a duty to the plaintiff, a breach of that duty, and that the breach was the proximate cause of plaintiff's injuries. While the existence of a duty must be determined as a matter of law, whether a duty has been breached and whether the breach proximately caused an injury are factual matters. In the case of Charles Hollister versus John North, it was held a citizen and taxpayer named Hollister filed a declaratory judgment action alleging a violation of Section 3 of the Corrupt Practices Act, or now called the Public Officer Prohibited Activities Act. The complaint charged that the Board of Education members named were involved in a conflict of interest because of the employment of their spouses as teachers in the school district, and then asked that the contracts between the Board of Education and the wives of the members of the board be declared null and void. Now, let me just stop here for a second. We start off with a lot of case law because we believe that it is in our reading and studying case law that we gain some sort of understanding of how the judges interpret the laws that have been established not only by the Constitution but by the legislature. So we just wanted to point that out. I know we start off a lot with reading from case law, but we just wanted to give you our reasons for doing such. Let us continue. The trial court found that the interest alleged, the marital relationship, did not amount to an interest in violation of the statute. We agree. Two preliminary issues present themselves: whether the appeal should be dismissed because the case is moot, and whether the plaintiff has standing. If the question presented is of substantial public interest, the case may be decided even if it is moot in the normal sense. But three conditions are necessary. One, the question must be of a public nature. Two, there must be a need for an authoritative determination for future guidance of public officers. And three, the issue is likely to reoccur. All three of these conditions are clearly present to a great extent in this case. One, whether a public officer is in violation of the conflict of interest laws is an issue greatly affecting the public good. Two, the particular situation alleged is quite highly likely to reoccur, even if it does not presently exist. 3. The uncertainty of the law on this question affects the confidence of the public in its elected officials and serves to discourage participation in our public institutions. Let's read 3 again. 3. The uncertainty of the law on this question affects the confidence of the public in its elected officials and serves to discourage participation in our public institutions. Accordingly, the motion to dismiss the appeal is denied. Defendants also argued that Hollister has no standing to bring suit. We disagree. Taxpayer suits to restrain illegal use or misappropriation of public funds have a long history in Illinois. Jones versus O'Connell. C. Mr. Justice Schaefer's dissent in Joss versus Kerner for a recapitulation of that history. The complaint here alleges that defendant's conduct is a breach of the fiduciary duty owed by public officials to the people they represent, in that it alleges a conflict of interest and public funds wrongfully expended in breach of the statute. A public office is a public trust. A public office is a public trust, and the holder thereof cannot use it directly or indirectly for a personal profit, and officers are not permitted to place themselves in a position in which personal interest may come into conflict with the duty which they owe to the public. A public office is a public trust. Borough councilmen, as fiduciaries and trustees of the public interest, must serve that interest with the highest fidelity. The law tolerates no mingling of self-interest. It demands exclusive loyalty. Driscoll versus Burlington Bridge Company. Certiorari denied. Bell versus Driscoll. Also, Ames versus Board of Education of Montclair. The theory is that a public officer assumes the same fiduciary relationship toward the citizens of his community as a trustee bear to his Sesque Trust or beneficiary. Pressy versus Township of Hillsborough. Certiorari denied. They have the right to expect that in everything that appertains to their business or welfare, he will exercise his best judgment, unaffected and undiluted by anything which might inure to his own interests as an individual. The failure of a public officer to perform a public duty can constitute an individual wrong only when some person can show that in the public duty was involved also a duty to himself as an individual, and that he has suffered a special or a peculiar injury by reason of its non-performance. James Lucietto versus James Kingen. Now, let's point out one of the statutes that state legislators passed to prohibit public officers from using their positions to engage in self-dealing transactions, which we've already pointed out. It was called the Public Officer Prohibited Activities Act. But let us continue. In the 1870 Illinois Constitution, we find in Article 4, Section 5, members of the General Assembly, before they enter upon their official duties, shall take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of Illinois, and will faithfully discharge the duties of senator or representative according to the best of my ability, and that I have not knowingly or intentionally paid or contributed anything or made any promise in the nature of a bribe to directly or indirectly influence any vote at the election at which I was chosen to fill the said office, and have not accepted, nor will I accept or receive directly or indirectly any money or other valuable thing from any corporation, company, or person for any vote or influence I may give or withhold on any bill, resolution, or appropriation, or for any other official act. Any member who shall refuse to take the oath herein prescribed shall forfeit his office, and every member who shall be convicted of having sworn falsely to or of violating his said oath shall forfeit his office and be disqualified thereafter from holding any office of profit or trust in this state. The Illinois General Assembly has provided with respect to prohibited interest in contracts. Now, as we said, we already spoke of this statute, but we just quoted the oath that members of the Senate and House of Representatives take, because we believe that this statute was written in conjunction, if you will, or based on that particular oath that the senators and House of Representative members take. Let us continue. The Illinois General Assembly has provided with respect to prohibited interest in contracts, Section 3, prohibited interest in contracts. No person holding any office, either by election or appointment under the laws or constitution of this state, may be in any manner financially interested, directly in his own name, or indirectly in the name of any other person, association, trust, or corporation, in any contract or the performance of any work in the making or letting of which such officer may be called upon to act or vote. No such officer may represent, either as agent or otherwise, any person, association, trust, or corporation with respect to any application or bid for any contract or work in regard to which such officer may be called upon to vote. Nor may any such officer take or receive or offer to take or receive, either directly or indirectly, any money or other thing of value as a gift or bribe or means of influencing his vote or action in his official character. Any contract made or procured in violation hereof is void. This section shall not apply to any person serving on an advisory panel or commission, to any director serving on a hospital district board as provided under subsection A-5 of section 13 of the hospital district law, or to any person serving as both a contractual employee and as a member of a public hospital board as provided under Article 11 of the Illinois Municipal Code in a municipality with a population between 13 and 16,000 that is located in a county with a population between 50 and 70,000. Conflict of interest. The legislative intent in enacting these statutes was to codify sweeping prohibitions against public officials and officers engaging in conduct which divides their loyalty between their personal interests and their fiduciary duties. The statute is unique because only public officials can violate its provisions. These officials are held in public trust and owe a fiduciary duty to the people they represent. See City of Chicago, X. Rail Cohen versus Keene. The high standard of conduct demanded of public officers, coupled with the broad, sweeping language of the statute, permits no other interpretation as to its intent and meaning. The conflict of interest theory is based on the fact that an individual occupying a public position uses the trust imposed upon him and the position he occupies to further his own personal gain, and it is the influence he exerts in his official position to gain personally in spite of his official trust, which is the evil the law seeks to eradicate. The conflict of interest theory is based on the fact that an individual occupying a public position uses the trust imposed upon him and the position he occupies to further his own personal gain, and it is the influence he exerts in his official position to gain personally in spite of his official trust, which is the evil the law seeks to eradicate. One more time. The conflict of interest theory is based on the fact that an individual occupying a public position uses the trust imposed upon him and the position he occupies to further his own personal gain, and it is the influence he exerts in his official position to gain personally in spite of his official trust, which is the evil the law seeks to eradicate. In the case of Wright versus DeArmond, it was held. Conflict of interest statutes address a problem of compelling importance to a state's capacity to govern justly, preventing public corruption or the appearance of corruption. Conflict of interest statutes address a problem of compelling importance to a state's capacity to govern justly, preventing political corruption or the appearance of corruption. One more time. Conflict of interest statutes address a problem of compelling importance to a state's capacity to govern justly, preventing political corruption or the appearance of corruption. Our holding is also compatible with the articulated purpose of the official misconduct and conflict of interest statutes, which is to keep the loyalties of public officials to their public trust undivided and to compel them to act in a lawful manner while acting in their official capacities. In the case of Austin, Michigan Secretary of State versus Michigan State Chamber of Commerce, it was held. The state contends that the unique legal and economic characteristics of corporations necessitates some regulation of their political expenditures to avoid corruption or the appearance of corruption. See Federal Election Commission versus National Conservative Political Action Committee. Preventing corruption or the appearance of corruption are the only legitimate and compelling government interests thus far identified for restricting campaign finances. Preventing corruption or the appearance of corruption are the only legitimate and compelling government interest that's thus far identified for restricting campaign finances. One more time. Preventing corruption or the appearance of corruption are the only legitimate and compelling government interest thus far identified for restricting campaign finances. State law grants corporations special advantages such as limited liability, perpetual life, and favorable treatment of the accumulation and distribution of assets that enhance their ability to attract capital and to deploy their resources in ways that maximize the return on their shareholders' investments. We therefore have recognized that the compelling governmental interest in preventing corruption supports the restriction of the influence of political war chests funneled through the corporate form. It is well settled that a fiduciary relationship exists between trustee and beneficiary as a matter of law. Under the Fiduciary Obligations Act, a fiduciary includes a trustee under any trust. The Act further specifies that in any case not provided for in this Act, the rules of law and equity, including the law merchant, and those rules of law and equity relating to trusts, agency, negotiable instruments, and banking shall continue to apply. The relationship between trustee and beneficiary is such that the duties rest upon the trustee to serve the interests of the beneficiary with complete loyalty, excluding all self-interest. It sounds just like what the Conflict of Interest Statute or the Public Officer Prohibited Activities Act states, or the compelling interest of the Conflict of Interest statutes. Additionally, we note the well-established principle that a trustee cannot simply delegate his own duty to provide information to his beneficiary or force the beneficiary to find other avenues for information he is rightfully owed. The law does not contemplate that a beneficiary of a trust must set in motion the process of a court in order to obtain what he is entitled to. As the long established high duties of a trustee were explained by the court in the matter of the trusteeship under the last will and testament of a Hartzell. Although purely ministerial powers or duties may be delegated by a trustee, generally a trustee may not delegate powers and duties involving an exercise of judgment and discretion. A trustee must use care and diligence in the discharge of his powers and duties. He is held to a high standard of conduct and must exercise the utmost or highest good faith in the administration of the trust, the same as a public officer in administering the public trust. We just point that out to say that their duties have similarities. Adherence to fundamental principles dictates that a trustee is held to a high standard of conduct and must exercise the utmost or highest good faith in the administration of the trust, and that acting with good faith in administering the trust means that the trustee must act honestly and with undivided loyalty to the trust, not merely with regard or not merely with the standard of the workaday world, but with the most sensitive degree of honor. Laubner versus J.P. Morgan Chase Bank, N.A. Thus, under our de novo review, we cannot find any superseding proximate cause as a matter of law sufficient to dismiss plaintiff's cause of action. Judge or administrator is a fiduciary. The judicial article of the Illinois Constitution provides in pertinent part excuse me, Section 13, prohibited activities. A. The Supreme Court shall adopt the rules of conduct and for associate, let us start again. A. The Supreme Court shall adopt rules of conduct for judges and associate judges. B. Judges and associate judges shall devote full time to judicial duties. They shall not practice law, hold a position of profit, hold office under the United States or this state or unit of local government or school district or in a political party. Section 14, Judicial Salaries and Expenses. Fee officers eliminated. Judges shall receive salaries provided by law which shall not be diminished to take effect during their terms of office. All salaries and such expenses as may be provided by law shall be paid by the state except that appellate, circuit, and associate judges shall receive such additional compensation from counties within their district or circuit as may be provided by law. There shall be no fee officers in the judicial system. Illinois Constitution, 1970, Article 6, Sections 13 and 14. Illinois Supreme Court Rules. Canon 1, Rule 1.1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Canon 1, Rule 1.2, Promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Or we could say corruption and the appearance of corruption. Comments. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. A judge should expect to be the subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Let's read that again. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. One more time. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary because it is not practicable to list all such conduct. The rule is necessarily cast in general terms. 4. Judges should participate in activities that promote ethical conduct among judges and lawyers, support professionalism within the judiciary and the legal profession, and promote access to justice for all. 5. Actual improprieties include violation of law. These are what the improprieties are. Violation of law, violation of court rules, or violation of provisions of this code. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge violated this code. This is for the appearance of impropriety. Is whether the conduct will create in reasonable minds a perception that the judge violated this code or engaged in other conduct that reflects adversely on the judge's honesty, impartiality, temperament or fitness to serve as a judge. 6. A judge should initiate and participate in community outreach activities for the purpose of promoting public understanding of and confidence in the administration of justice. In conducting such activities, the judge must act in a manner consistent with this code. Rule 2.2, impartiality and fairness. A judge shall uphold and apply the law and shall perform all duties in judicial office fairly and impartially. Comment. To ensure impartiality and fairness to all parties, a judge must be objective and open minded. 2. Although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. 3. Good faith. Errors of fact or law do not violate this rule. 4. It is not a violation of this rule for a judge to make reasonable accommodations consistent with the law and court rules to pro se litigants the opportunity to have their matters fairly heard. Rule 2.4, External influence on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. B. A judge shall not permit family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct or judgment. 3. C. A judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. This big one. C. A judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. One more time. A judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. Comments. 1. An independent judiciary requires that judges decide cases according to the law and facts without regard to whether particular laws or litigants are popular or unpopular with the public, the media, government officials, or the judge's friends or family. Confidence in the judiciary is eroded if judicial decision making is perceived to be subject to inappropriate outside influences. Say that again. Confidence in the judiciary is eroded if judicial decision making is perceived to be subject to inappropriate outside influences. One more time. Confidence in the judiciary is eroded if judicial decision making is perceived to be subject to inappropriate outside influences. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. B. A judge may encourage parties to a proceeding and their lawyers to settle matters in a dispute, but a judge shall not act in a manner that coerces any party. Comments. 1. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. Let's read that again. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. One more time. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. 2. The judge plays an important role in overseeing the settlement of disputes, but should be careful that efforts to further settlement do not undermine any party's right to be heard according to law. Judges should be mindful of the effect settlement discussions can have not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality, despite a judge's best efforts. There may be instances when information obtained during the settlement discussions could influence a judge's decision making during trial, and in such instances, the judge should consider whether disqualification may be appropriate. And in such instances, the judge should consider whether disqualification may be appropriate. And in such instances, the judge should consider whether disqualification may be appropriate. See Rule 2.11A1. Rule 2.11, disqualification. A. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. 1. The judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of facts that are in dispute in the proceeding. 2. The judge knows that the judge's spouse or domestic partner, a person within the third degree of relationship to either of them, or the spouse or domestic partner of such person is a party to the proceeding, or an officer, director, general partner, managing member, or trustee of a party. B. Acting as a lawyer in the proceeding. C. A person who has more than a de minimis interest that could be substantially affected by the proceeding. Or D. Likely to be a material witness in the proceeding. 3. The judge knowingly, individually, or as a fiduciary, or the judge's spouse, domestic partner, parent, or child, wherever residing, or any other member of the judge's family residing in the judge's household has an economic interest in the subject matter in controversy, or is a party to the proceeding. 4. The judge, while a judge or a judicial candidate, has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to reach a particular result in a particular way in the proceeding or controversy. 5. The judge, A. served as a lawyer in the matter, B. represented any party to the matter while engaged in the private practice of law within a period of 7 years following the last date on which the judge represented the party. C. Within the preceding 3 years, was associated in the private practice of law with any law firm or lawyer currently representing any party in the matter, provided that referral of cases when no monetary interest was retained shall not be deemed an association within the meaning of this paragraph. D. Served in governmental employment and in such capacity participated personally and substantially as a lawyer or public official concerning the matter, or has publicly expressed in such capacity an opinion concerning the merits of the particular matter. E. Was a material witness concerning the matter, or F. Previously presided as a judge over the matter in another court. B. A judge shall keep informed about the judge's personal and fiduciary economic interests and make a reasonable effort to keep informed about the personal economic interests of the judge's spouse or domestic partner and minor children residing in the judge's household. C. A judge is subject to disqualification under this rule, and other than for bias or prejudice under paragraph A1, may disclose on the record the basis of the judge's disqualification and may ask the parties and their lawyers to consider, outside the presence of the judge and court personnel, whether to waive disqualification if following the disclosure the parties and lawyers agree without participation by the judge or court personnel that the judge should not be disqualified, the judge may participate in the proceeding. The agreement shall be incorporated into the record of the proceeding. Comments. 1. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned. Say that again. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned. One more time. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. For example, the participation in a matter involving a person with whom the judge has an intimate relationship or a member of the judge's staff may require disqualification. 2. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Read that again. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. One more time. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. 3. The rule of necessity may override the rule of disqualification. For example, a judge might be required to participate in a judicial review of a judicial salary statute or might be the only judge available in a matter required immediate judicial action, such as a hearing on probable cause or a temporary restraining order. In matters that require immediate action, the judge must disclose on the record the basis of possible disqualification or the basis for this possible disqualification and make reasonable efforts to transfer the matter to another judge as soon as practicable. 4. The fact that a lawyer in a proceeding is affiliated with a law firm with which a relative of the judge is affiliated does not itself disqualify the judge. If, however, the judge's impartiality might reasonably be questioned under paragraph A, or the relative is known by the judge to have an interest in the law firm, that could be substantially affected by the proceeding under paragraph A2C, the judge's disqualification is required. 5. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. 6. Economic interest, as set forth in the terminology section, means ownership of more than a de minimis legal or equitable interest, except for situations in which a judge participates in the management of such a legal or equitable interest, or the interest could be substantially affected by the outcome of a proceeding before a judge. It does not include an interest in the individual holdings within a mutual or common investment fund, an interest in securities held by an educational, religious, charitable, fraternal, or civic organization in which the judge or the judge's spouse, domestic partner, parent, or child serves as a director, officer, advisor, or other participant. 3. A deposit in a financial institution or deposits of proprietary interest the judge may maintain as a member of a mutual savings association or credit union or similar proprietary interest. Or 4. An interest in the issuer of government securities held by the judge. 7. A judge's use of social media or social networking platforms may create the appearance of a relationship between the judge and litigants or lawyers who may appear before the judge. Whether a relationship would cause the judge's impartiality to reasonably be questioned depends on the facts. While the labels used by the social media or social networking platform, e.g., friend, are not dispositive of the nature of the relationship, judges should consider the manner in which the rules on disqualification have been applied in traditional contexts and additional ways in which social media or social networking platforms may apply any connection to the judge. It has been long established in Illinois that a public officer occupies a fiduciary relationship to the political entity on whose behalf he serves. The most well-known of a public official's fiduciary duties is that of undivided loyalty to the office and the people whom he serves. Emanating in part from Section 3 of the Illinois Corrupt Practices Act, now Public Officer Prohibited Activities Act, this duty is sweeping and commands a public official to refrain from self-dealing in conflicts of interest. The duty of loyalty is not the only fiduciary duty Illinois recognizes for its public officials. Other duties may be prescribed by statute or found in common law. The right to a civil remedy for a breach of a statutorily created fiduciary duty is clear. Fraud, in its elementary common law sense of deceit, and this is one of the meanings that fraud bears in the statute, see United States versus Dial, includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, including, in the case of a judge, the litigants who appear before him, and if he deliberately conceals material information from them, he is guilty of fraud. When a judge is busy soliciting loans from counsel to one party and not telling the opposing counsel, let alone the public, he is concealing material information in violation of his fiduciary obligations. Constructive fraud includes any act, statement, or omission which amounts to positive fraud or which is construed as a fraud by the courts because of its detrimental effect upon public interest and public or private confidence. This claim requires the existence of a confidential or fiduciary relationship. Indeed, a plaintiff claiming constructive fraud must show that defendant 1 breached the fiduciary duty he owed to plaintiff, and 2 knew of the breach and accepted the fruits of the fraud. Constructive fraud is a breach of legal or equitable duty which, without regard to moral guilt or intent of the person charged, the law declares fraudulent because the breach tends to deceive others, violates public or private confidence, or injures public interests. While it does not require a showing of intent to deceive or dishonesty of purpose, it does require a fiduciary or confidential relationship. Most importantly for our purposes, the breach of duty by the person in the confidential or fiduciary relationship must induce justifiable reliance by the other to his detriment. 37 Am. Juris 2nd, Fraud and Deceit, Section 9. See also in the matter of McDonald's estate, 1058. Difference between actual and constructive fraud is that former, actual, requires actual intent to deceive, while other is characterized as breach of a duty actionable irrespective of moral guilt and arising out of a confidential relationship. Walk versus Ring. Breach of fiduciary duty by fraudulently concealing treatment errors tolls statute of limitations until concealment is discovered or reasonably should be discovered, or presumably until the plaintiff had actual knowledge of underlying mistreatment. A conflict of interest occurs when the trustee facilitates the sale or purchase of trust property to a person or entity to which the trustee owes a fiduciary duty. Elements of breach of fiduciary duty. Under Illinois law, upon which this theory is based, recovery for a breach of fiduciary duty requires proof of 3 elements. 1, a fiduciary duty exists. 2, that the fiduciary duty was breached. And 3, that such breach proximately caused the injury of which the plaintiff complains. The term proximate cause describes 2 distinct requirements: cause in fact and legal cause. Cause, in fact, exists where there is a reasonable certainty that a defendant's acts caused the injury or damage. A defendant's conduct is a cause in fact of the plaintiff's injury only if that conduct is a material element and a substantial factor in bringing about the injury. A defendant's conduct is a material element and a substantial factor in bringing about the injury. A defendant's conduct is a material element and a substantial factor in bringing about an injury if, absent that conduct, the injury would not have occurred. Legal cause, by contrast, is essentially a question of foreseeability. The relevant inquiry here is whether the injury is of the type that a reasonable person would see as a likely result of his or her conduct. To recover damages based on negligence, the plaintiff must allege and prove that the defendant owed a duty to the plaintiff, a breach of that duty, and that the breach was the proximate cause of the plaintiff's injuries. While the existence of a duty must be determined as a matter of law, whether a duty has been breached, and whether the breach proximately caused an injury are factual matters. The guiding principle by which the court fixes damages in the event of a trustee's self-dealing transaction is the rule that the beneficiaries are entitled to be put in a position which they would have occupied if no breach of duty had been committed. Thus, a beneficiary has three alternative remedies against a self-dealing trustee or fiduciary. First, the trustee is charged with any loss to the trust estate. Second, the trustee is charged with any profit actually made by the trustee through the breach of trust. Third, the beneficiary may recover from the trustee any lost profits which would have accrued to the estate had there been no such breach of trust. Furthermore, if a self-dealing trustee has transferred trust property to a third person, a beneficiary has the right to follow or trace the property into the hands of such third person unless such third person is a bona fide purchaser without notice of such breach. Moreover, if the trustee has reinvested the trust proceeds into a new traceable investment, the beneficiary has the option to follow such proceeds into the new investment or to hold the trustee personally liable for the proceeds. The equity will raise a constructive trust in the circumstances of this transaction to the extent of a fiduciary's unfair profiting at the beneficiary's expense. A constructive trust is one raised by operation of law, as distinguished from a trust created by express agreement between the settlor and the trustee. A constructive trust is created when a court declares the party in possession of wrongfully acquired property as the constructive trustee of that property, because it would be inequitable for that party to retain possession of the property. The sole duty of the constructive trustee is to transfer title and possession of the wrongfully acquired property to the beneficiary. A constructive trust is generally imposed in two situations. First, where actual or constructive fraud is considered as equitable grounds for raising the trust, and second, where there is a fiduciary duty and a subsequent breach of that duty. A constructive trust may also arise when duress, coercion, or mistake is present. Some form of wrongdoing is a prerequisite to the imposition of a constructive trust. A constructive trust will not be imposed unless the complaint makes specific allegations of wrongdoing, such as fraud, breach of fiduciary duty, duress, coercion, or mistake. Furthermore, the grounds for imposing a constructive trust must be so clear, convincing, strong, and unequivocal as to lead to but one conclusion. Illinois law holds that a constructive trust may be imposed when so required by equity and good conscience. The presence of fraud is not controlling, and a constructive trust is not restricted to grounds of fraud or breach of fiduciary relationship. In Charles Hester Enterprises versus Illinois Founders Insurance Company, on which the majority relies for a requirement of wrongdoing, this court recognized disjunctively that some form of wrongful or unconscionable conduct is required for imposition of a constructive trust. Federal conflict of interest law. Now, let us look at what the federal government prohibits in terms of public officers being prohibited from having a personal interest while operating in their official capacity. In the course of their official duty, they have a personal interest in the outcome of a contract. Or in the course of their official duty, they have a personal interest in the outcome of a contract. We will quote the case of United States versus Mississippi Valley Generating Company, where it was said, the obvious purpose of the statute is to ensure honesty in the government's business dealings by preventing federal agents who have interests adverse to those of the government from advancing their own interests at the expense of the public welfare. United States versus Chemical Foundation. The moral principle upon which the statute is based has its foundation in the biblical admonition that no man can serve two masters. The moral principle upon which the statute is based has its foundation in the biblical admonition that no man can serve two masters. One more time. The moral principle upon which the statute is based has its foundation in the biblical admonition that no man can serve two masters. Matthew 6:24. A maxim which is especially pertinent if one of the masters happens to be economic self-interest. Consonant with this salutary moral purpose, Congress has drafted a statute which speaks in very comprehensive terms. Section 434 is not limited in its application to those in the highest echelons of government service or to those government agents who have only a direct financial interest in the business entities with which they negotiate on behalf of the government, or to a narrow class of business transactions, nor is the statute scope restricted by numerous provisos and exceptions, as is true of many penal statutes. Rather, it applies without exception to whoever is directly or indirectly interested in the pecuniary profits of contracts of a business entity with which he transacts any business as an officer or agent of the United States. Violation of due process of law in the case of Hugh M. Caperton versus A.T. Massey Coal Company Incorporated. It was said the due process clause incorporated the common law rule requiring recusal when a judge has a direct, personal, substantial, pecuniary interest in a case, Toomey versus Ohio. But this court has also identified additional instances which, as an objective matter, require recusal where the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. Withrow versus Larkin. Two such instances place the present case in proper context. The first involved local tribunals in which a judge had a financial interest in a case's outcome that was less than what would have been considered personal or direct at common law. In Toomey, a village mayor with authority to try those of violating a law prohibiting the possession of alcoholic beverages faced two potential conflicts. Because he received a salary supplement for performing judicial duties that was funded from the fines assessed, he received a supplement only upon a conviction, and sums from the fines were deposited to the village's general treasury fund for village improvement and repairs. Disqualification was required upon the principle that every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the latter due process of law. In Ward versus Monroeville, a conviction in another mayor's court was invalidated even though the fines assessed went only to the town's general fisc because the mayor faced a possible temptation created by his executive responsibilities for village finances. Recusal was also required where an Alabama Supreme Court justice cast the deciding vote upholding a punitive damages award while he was lead plaintiff in a nearly identical suit pending in Alabama's lower courts. Aetna Life Insurance Company versus Lavoie. The proper constitutional inquiry was not whether, in fact, the justice was influenced, but whether sitting on that case would offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. While the degree or kind of interest sufficient to disqualify a judge could not be defined with precision, the test did have an objective component. 2. The second instance emerged in the criminal context where a judge had no pecuniary interest in the case but had determined in an earlier proceeding whether criminal charges should be brought and then proceeded to try and convict the petitioners. In the matter of Murchison finding that no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome, the court noted that the circumstances of the case and the prior relationship required recusal. The judge's prior relationship with the defendant, as well as the information acquired from the prior proceeding, was critical in reiterating that the rule that a defendant in criminal contempt proceedings should be tried before a judge other than the one reviled by the contemptor, Mayberry versus Pennsylvania, rests on the relationship between the judge and the defendant. At 465, the court noted that the objective inquiry is not whether the judge is actually biased, but whether the average judge in his position is likely to be neutral or there is an unconstitutional potential for bias. In the case of Marshall, Secretary of Labor versus Jericho Incorporated, it was said the Due Process Clause entitles a person to an impartial and disinterested tribunal in both civil and criminal cases. This requirement of neutrality in adjudicative proceedings safeguards the two central concerns of procedural due process: the prevention of unjustified or mistaken deprivations, and the promotion of participation and dialogue by affected individuals in the decision-making process. The neutrality requirement helps to guarantee that life, liberty, or property will not be taken on the basis of an erroneous or distorted conception of the facts or the law. See Matthews versus Eldridge. At the same time, it preserves both the appearance and reality of fairness, generating the feeling so important to a popular government that justice has been done. Joint Anti-Fascist Committee versus McGrath. By ensuring that no person will be deprived of his interest in the absence of a proceeding in which he may present his case with assurance that the arbiter is not predisposed to find against him. And this concludes our video for today. We thank you once again for tuning in to Kairu, Know Your Rights University. Peace and blessing to you all.